are we going to talk about today, Mr. Grissett?
Okay, we're going to talk about IP portfolio development in the medtech space, and I will share my screen. Everybody see that?
We can.
All right. Now what do you see?
We see what you want us to see.
I'd rather you just see the slides. Do you see?
Yes, we see the slide. Yes, we only see the slide. We don't see the next page or any of your notes or anything like that.
Okay.
But before you start, and I'm confident you'll cover this in the presentation, I think a lot of folks, whenever we have an IP talk, whenever I'm asked an IP question, it's always when to show your hand. If I file this, then it's public knowledge. My competitor can get at it. And then on the other side, which you well know because you followed Dr. Albert at 10X just a month ago, today even, hey, if Apple can come after you, what hope do we have? I mean, he's like one of the only people I know that has a war chest that can begin to take on an Apple who comes after your patent. So what's the point? So lots of fodder as we kick off developing an IP strategy in medtech. Put your hands together for Gregory Grissett, Esquire.
Thank you. Thank you, Joe. We'll get right in. I will there we go. All right. Developing an IP strategy in medtech. 3 parts to the talk today. How IP can be used to protect a new product. Well, we'll do a basic overview of the different forms of IP and maybe just scratch the surface of what is the right of a patent. And part 2 is a question that we'll help answer together is your revenue model protected in view of the patents? And then 3, that what Joe alluded to, is what is your risk position regarding competitor patents? But before I get, well, let me go into overview of IP. There's really 4 types: trademarks, copyrights, trade secrets, and patents. Trademarks are sources of goods or services. It's your brand. It identifies a source. And as long as you're using it in commerce, a word, a logo, a phrase, you have trademark rights in that. And there's different steps you can take to effectuate different trademark rights. We won't get into that in detail, but just know that a trademark is really protecting your brand. Copyrights, this is expressions, creative works. The easy ones are art, music, song, but it's literature. It's your web page. It's some parts of software. But anything that's expressed, not the idea behind it, but just its expression. Trade secrets, this is a very short paraphrase definition, but it's valuable secret information, and you keep it secret by taking reasonable steps to maintain its secrecy. Trade secrets are pretty broad. It could be recipes, it could be sales information, customer lists, financial data. It's a broad scope of definition, and it lasts as long as you keep it secret. Patents, this is about products and processes and devices and compositions and machines. Sometimes you may hear a patent attorney say these are about technical solutions to technical problems, inventions, so to speak. And of all the IP rights, this is the one with the shortest term. It's 20 years from filing. And part of that is a recognition of the power of this particular right. We're going to spend pretty much all the rest of our talk talking about patents. But before I go to the next slide, I do want to just address one thing that Joe raised. You'll see it won't be picked up in the slide, but when should you file for patent protection? It's relatively simple, meaning it's before you publish, before you disclose to a third party, or before you offer it for sale. Those 3 things are the acts or events that start a time period in the United States by which you must file for patent protection.
I have a quick marketing question on trademarks. I vaguely recall that if you make your brand possessive, you weaken your trademark. For example, when I worked at Cardiac Science, for me to say Cardiac Science's products are great, by making cardiac science possessive, that it has products, that it weakens the trademark. Can you explain that?
I don't know if I would necessarily agree that it weakens the trademarks. There's other things that you can do or not do that will weaken trademarks. So, if you find somebody that has a slight using a slight variation of your name, certainly within your marketplace, but even within an adjacent market, and you don't try to address that by a cease and desist letter or policing your trademarks, that can certainly weaken your trademarks. You do have to use it in a particular way, meaning the brand should be used with the good or service that is the right, literally affixed to it. So if we're doing medical device products, I might like to see your brand directly on the product. I've worked with a company where we go through, just make sure you put it, the Manta vascular closure device, it's literally written on the product. That's the proper usage. Now, you wouldn't necessarily, make that, possessive, but in the course of your marketing, you may have to use a possessive language. But I don't see that as a big risk as the other issues that I raised.
Thank you.
Sure. Okay, I'm going to go through an example of how these different rights interrelate to protect a product, and I'll read and kind of paraphrase some of this, but you can read along. Nuco develops a health monitor. It has a fancy new sensor that really obtains these physiological characteristics. It's got a new communication system that helps with data transfer. It does the work of 3 different devices and has superior data sets. Marketing calls it new device. It's got this ergonomic shape. It looks really good. In developing this product, they had to come up with a new coding scheme developed in-house. It's robust, intuitive. That coding scheme was used to create software that operates the sensor. And then there was some open source thrown in there. But the product was also based on this compilation of physiological data obtained by the company for the last 20 years that others don't have. So how does those 4 IP rights apply, to this example? Well, trademarks, I think, the easy one, Nuco, new device, those are all possible trademarks for this product or your brand. Copyrights is really in a lot of different places. Perhaps the ergonomic shape, there's some limits there. Perhaps the coding scheme and the software, and open source software obviously brings in some copyright issues. The open source issue is more or less manageable, but just be mindful that there are some risks just in terms of ownership that you may need to address. Now, if we look at patents, patents can be applied in a lot of different places to the health monitor itself, the new sensor module. Perhaps a method of increasing data rates in a sensing device. The ergonomic shape could be the subject of a design patent. To some extent, the coding scheme and the software can also be part of a patent strategy. And then trade secrets, perhaps part of the coding scheme or the software, and certainly the physiological data. But as you see all these rights overlaid on the slide, there's a lot of interrelation. And I think just be mindful that it's developing an IP strategy isn't necessarily saying, all right, I got my trademark, I got my copyrights, I got my patents, I have my trade secrets. You may have all of those, but they do need to work somewhat in concert so that you're not undermining one versus the other. And know that there's a lot of different ways that you can apply certainly the patent system to the space that we operate in, especially if it involves software. So just an example of how IP might relate to a product that you might be working on. Now, from this point forward, we're going to focus on patents mainly. And if you're at the 10X this April, you'll recognize this slide, but it's an important thing that I think to understand. Patents grant the owner the right to prevent third parties or others from making, using, and selling or importing in the U.S. an invention as claimed in a patent. Now, when I look at this definition, I think about how commercially focused it is: making, using, selling, importing. These are all things that are really focused on the business of buying and selling goods. Now, this patent right is given in exchange for disclosure of the invention. When you file for a patent application, if you've done this, you have to disclose it and enable the claims in a way that would allow the world essentially to make and use it in exchange for this particular right. Now, patent claims that in my view, this is why you hire patent attorneys. You either hiring him to help draft the claims in accordance with some of the teachings that we'll talk about today, or you're hiring a patent attorney to attack a claim or to defend a claim. But this is where we spend most of our time, and is the more important aspect of patents. You can think of it like a deed or a fence around your property. The claim outlines this area in the market that gives you the right to prevent others from going inside of that area. It defines the scope as a rights, as I've said. And we'll come back to this idea, but valid claims are novel and non-obvious over the art. A patent has to be more than just the expression of something like a copyright. It requires just a bit higher standard of ingenuity or innovation, and we measure that by the doctrine of non-obvious currently. So patent claims are really where it's at when we're talking about patent strategy and IP strategy. Now, two concepts that I we'll just talk about a little bit. Whenever you have a product or this technology that you've been nurturing, on one hand, there's a question of patentability. Does your invention rise to the level of being awarded a patent by the United States Patent and Trademark Office? Right, on one hand. A related question, but legally distinct and different, is freedom to operate. Freedom to operate is focused solely on what you're going to sell, the product that is literally going to be in the package that you're going to ship from the warehouse to the hospital system. And the question in freedom to operate is, does the product infringe this valid claim of a U.S. patent? Now, they're going to be related because the common link here is the technology at issue, but the ability to get a patent doesn't give you freedom to operate, and freedom to operate doesn't really give you the ability to get a patent. They're separate, and we'll see some of how that plays out as the presentation progresses. All right, is your revenue model protected? This is a question I think is sort of a baseline in the medtech space, especially if there's any sort of scrutiny on the portfolio by way of investors or strategics that you may be working with. I'm not going to talk necessarily about what's patentable in this context or not. This is really more about assuming your invention is patentable. How is the best way to implement a strategy that helps protect your revenue model? And one way to do this, and well, let me back up. At a base level, your patent should cover your product. What is in that package that's going to be shipped, or the service that you're providing, that thing that you're getting revenue from, that you invoice your customers for. All right. This goes one step further and says, well, your product is sort of product protection is sort of a base case, but really covering different aspects of the value chain is where you're going to get some increase in value in your portfolio and give you a little bit more commercial options as your development and your commercialization progresses. We'll talk a bit more about that. And then utilizing the patent system to address competitive threats via what we call continuation applications. You can hold that term in the back of your mind. I'll define it a little bit later, but this is a way to address competitive threats. So here this is a very simple, basic value chain. You've got components that go into assembly, that's made into a product that is then, let's say in this example, implanted into the body via surgeon or surgical use. Now, the initial case is patents owned by Medco for this product is where you start, in my view. And what these patents do is essentially prevent your customer from buying it elsewhere, or prevent your competitors from selling it to your customer. So can your customer buy from a third party? Well, not without permission from Medco, because patent rights are about permission and unauthorized use of a product. So I've modified the value chain here a little bit to add what I call ancillary services. Now, ancillary services could be something that isn't necessarily the implant itself, but it could be software that you've created that helps the hospital manage their inventory better, or some other, adjunct to the product that helps with the sales cycle and helps close the deal, so to speak. Some of that might be software related, and there may be patent protection there. My view and a recommendation is, when you're developing a patent strategy, looking at what you're doing commercially requires that you, I think, of course, protect your product, but consider protection of these ancillary services, and then go one step further into the surgical use, how it's being used. In the medical device space, and especially when we're looking at implantable devices, the surgical use is really where you can tie your patent claims to some extent your indications that you're trying to achieve in your 510K or your other regulatory filings. That being said, I do want to talk about just two types of patent infringement. There's something called direct infringement and indirect infringement. All right. Direct infringement is where I sell a widget and my competitor sells a copying widget, and then I file suit and I can sue that competitor, and the case goes on. All right. Indirect infringement requires multiple parties. And as we know, in a lot of cases, the medical device company will sell the implant to the hospital, and the surgeon will then put that implant into the body. That is really an indirect infringement theory. Now, indirect infringement is just harder to prove. It requires a showing of inducing infringers to infringe the patent with an intent to do so. It's a higher evidentiary standard. It's just more difficult. So if I'm, your patent counsel and I had to choose between a direct infringement theory and an indirect infringement theory, I would choose a direct because it's just easier to prove. That being said, sometimes your method and your patentability is really tied up in the surgical use. And I wouldn't discard that because it also is part of the value chain. And again, this gives you a little bit different of a negotiating position, perhaps when you're protecting the product, the method, and these other services, and you have robust patent protection for that. Again, just patents are about withholding permission or getting permission from others that may be copying what you're doing. Now, let's go one step further and say, well, what if our patents can go back to assembly? If your contract manufacturer has the ability to make your product for somebody else, you can limit that to some extent by your commercial agreements. But if you had patents on the assembly and the method of manufacture, that would place an additional limit on one of your vendors or one of your partners. If you can go back to the component side, and this is maybe somewhat difficult, now you have patents that protect really everything up and down the value chain. Now, why would we do this now? Well, when I started practicing, investors, venture capital firms, we would focus on, all right, is there a product covered? And then we check the box and then we kind of move on. But now investors, when we're going through due diligence meetings, they're looking much more in depth at how the patents are creating competitive advantages. And the way you do that is to use these patents in a way to cover different aspects of the value chain to the extent that you can. So it's something that I see sophisticated investors increasingly looking at, using patents really as a barrier to entry and extracting value at different places, along the value chain. But if you have patents along this value chain, this does give you a different viewpoint and position with regards to your supply chain. There's always other factors and other risk in supply chain management, but the ability to have this negotiating position protected by patents backwards and forwards is helpful in my view. Okay, continuations. So if anybody has filed a patent application before, a continuation is you take literally the same document that you filed originally, you file a new one, you claim priority to the old one, and you may change the claims. So patent application A, filed January 1, 2015. Let's file a continuation. You can see it as patent application B. We file that before patent application A grants, and you have this application pending. Patent application B may have a device with a different focus. Patent application C may be a method. Now you can file these continuations for as long as there is patent term. All right, so in this example, patent term would go from 2015 to 2035. And you can file continuations for the next 20 years to keep a patent application pending or alive. And we'll explain why that's important right now. All right, first example, we file patent application A. It issues as a patent in 2018. Covers your product, great. You choose not to file a continuation, save money. That's fine. 2 years later, competitor enters the market. They copy just about everything of your product, but somehow avoid the patent claim, which is possible. But what can you do? Well, without continuations pending, there's really not much. There are some limited circumstances that you can reissue an application and bring it back to examination, but there's significant risk with that. You're really kind of stuck. If we look at the next example, let's say you filed your patent application, it issues in 2018, you've got your product covered, you file 2 applications, continuations, application B and application C, same example. 2 years later, competitor comes along, copies your product, but avoids the first patent somehow. Now, what do? Well, now I have 2 patent applications that are pending that it gives me the ability to adjust the claims to cover what the competitor is actually selling in the market. It gives you the ability to create this direct infringement situation and increases risk for that competitor. And that's what the continuations do. Now, you'll see if you've worked with strategics or large companies, you'll see continuation chains that may last 10 or 15 years. This is why that happens. Because they want to react to the market. The other thing is if you're licensing your product as a patent owner, and I have a licensee, it may start off great. Yeah, we'll pay these royalties. Eventually, somebody will ask, can we stop paying the licensor? Can we stop paying these royalties? Well, a continuation helps keep them a little bit honest because it's hard for them to avoid a patent if there's a continuation pending that can be used to cover whatever they're modifying. All right. So commercial products that have appreciable sales, any licensing, continuations is a strong recommendation.
I'd like to ask the folks on the call, have any of you been in any type of IP litigation of any kind? Raise your hand if you have. Andre, would you tell us about that?
Yeah, we had a device that a therapy device that an employee that was with us actually took components out of our facility, went out and started producing the unit themselves. It was a small company. We went into an infringement suit, and the costs mounted and mounted. It was a small company, and before even getting into court, we had spent about $350,000, and we weren't even in court yet. And the decision was to withdraw it without prejudice. And since it was a small company, it kind of kept our attorney said, the sword of Damocles hanging over their head, knowing that they couldn't go forward. It prevented them from getting funding and so forth. And in essence, the end result was we got rid of that competitor because of the fact that they just couldn't survive with that threat of a patent infringement case still hanging over their head. It was costly. We didn't get all the way through it, but I learned a lot from that.
That's really interesting. So by taking an action and withdrawing it, it still sent a message that said, if you get any further or you actually are profitable, we're coming after you.
Yeah, because we could still open it up. And Greg, obviously, what I've heard is that, if you're a company that does file infringements, you kind of are known that you may do it in the future. So it's a little bit of a deterrent to other people.
Right. Yeah. Filing a patent infringement lawsuit is significant. And I think any company that gets to the point where they're making a decision to do that has their own reasons, but it comes up in conversations I have with clients. You do it to send a message.
I'm curious, Greg, what's your thought about the $350,000 that he spent and not even went to court? I mean, that to me, my naive ear, sounds like an awful lot.
It is. If you look at it relative to the market, if their sales 10, 5, 10, 15, 20 million, and you're worried about encroaching on any of that, it is a lot, but it is a lot relative to what you're losing. I have some statistics on patent infringement cost today that we'll get into a little bit later. But part of
Andre's where they did that, is that something you've advised clients and engaged in frequently, infrequently?
I haven't worked with a client that has filed suit and then immediately withdrawn it, but certainly I've advised and represented companies in patent infringement lawsuits.
Well, Andre, your strategy wasn't originally to immediately withdraw it.
No, not at all, Greg. As a matter of fact, we brought in authorities, people specialists in the area to comment. We had all kinds of exhibits. We had demonstrations of the product. We were into it for probably a year. And then it was just decided that it just was costing too much and we couldn't go further.
Right.
So you probably could have done less and still sent the same message? Is that your takeaway, Andre?
In retrospect, you're probably right. Yes.
Right. Right.
I wonder what that minimum is before it's like, no, I'm serious, but I'm not going to do it now.
Well, that's hard. You can send cease and desist letters, but there's risk to that. You open yourself up to declaratory judgment jurisdiction. So
What does that mean, please?
Well, Greg, if I can interrupt.
yeah.
If I can interrupt. In our case, we did the cease and desist letters, and then they wanted to file to invalidate our patents. So that's why we decided to go straight into infringement, because we
That's
didn't
right.
want to get involved with defending our current patents. So that was our an offensive strategy, we called it.
I'm enjoying Andrea's smiling.
I
knowledge.
knew Andrea would be there.
Yeah.
Declaratory judgment is a lawsuit that a recipient of a cease and desist letter can file in federal district court to ask the court to say, we don't infringe, this patent's invalid. All right. Now, the risk of that, when you send a cease and desist letter, usually the plaintiff wants to file suit where they want to file suit. I'm in New Hampshire, maybe my client wants to litigate a suit in New Hampshire. If I send a cease and desist letter from my client that's based in East Texas, let's say, they can immediately file their declaratory judgment action in East Texas. That is not a forum I really want to litigate in for different reasons. So sending a cease and desist letter, in effect, is saying, I'm ready for litigation. It's the risk that you will be involved in it. All right. And you just lose a little bit of control.
Not only that, but if if your patent is not strong enough, and we all know that patents have different strengths and people spend different amount of time, resources, hire different quality people to search, write their patent applications, and they might get a patent from the patent office, but then if someone is going to go through this process and try to invalidate it, it might be fairly easy, and then you're left with no patent and no protection, and you've had to spend a ton of money.
Right. Agree completely.
Rick?
Yeah, I was wondering, before we got too far from it, on the patent continuation. If I understand it correctly, you file a patent continuation on following a patent that you filed before, and then somebody comes in and says, "Hey, I've got this thing I'm saying it's different, but it's really not." Is the advantage of the continuation that while it's being approved, you can add some claim information to it, or what is the?
So yeah, a continuation, it's a pending application, and at certain points during the application phase, you can change or modify your claims, more or less.
Got it. Okay.
There's some limits to that. And there's a question in the chat about a continuation in part. Continuation in part's a little bit different. It's filing a continuation with all this subject matter from, in my example, if I can get back there, I can't. Patent application A, and then you're adding new stuff. That has some effect on the priority date, but what the ability is to say, all right, maybe my claim was, and I use this example later. I'm claiming a gray gizmo, but my disclosure allows me to claim a black gizmo, but I didn't claim that in the patent. Then I can change my claim from a gray gizmo to a black gizmo and now cover the product. So there's some limits, of course, with anything that we do, but continuations, it just gives you options, I'd say.
And this is the value of having a good patent attorney help you write the application, because it matters what's in the application. Right. In order to try to, to have this strategy, to have the option in the future to change claims and have new claims, you have to have all the information already in the application. So capturing as much as possible from the get-go is super important, and a good patent attorney can help you sort of figure out all the things that you can put in there to have the option later down in the timeline to get more out of it.
Andrew makes a great point. For the strategy that I'm talking about to work, I have to be able to draft a claim in accordance with patent rules that covers the product, which presumes really that you need, when you're starting with your provisional, you're really thinking about, well, what would a competitor do? Describe that competitive embodiment, and then do that again and again, and again is one way to do it, so that you can point to an example that says, look, this competitive product is like example B, or what have you, and I can draft a claim for that. That is a great point. So let me see. All right, protect as much of the value chain, make use of continuations. That's the lesson from this part. So patents on core technology, they help protect your revenue model, and core technology are the value chain. Continuation patents, as I said, they help limit encroachment. And then importantly, and this is something I've seen over and over again, robust patent coverage attracts capital. And it isn't a check the box sort of analysis anymore. It is asking the questions that Andrea raised in your disclosure. Do you really have a description of what's your revenue model? Do you really have a description in your patent application of some reasonable alternatives? That is robust patent coverage, and that's what will help attract capital, in the future. We're going to switch gears, and we're going to talk about risk and avoiding patent infringement or IP infringement. All right, you develop a product in close to market release. You haven't done a patent search to assess your risk of infringement. Maybe you've done a patentability search, but have you done a search to assess risk of infringement? And this is really a freedom to operate study. And I define this as it's a search and analysis of relevant patents to determine the risk of patent infringement for marketing a product or service in the United States. Again, it compares what your commercial product is essentially to the claims of a US patent. Why do we do this? Well, it's a business tool. Founders, CEOs, investors want to evaluate risk of a product launch or product development pathway. This is sort of the practical benefit of doing an FTO study. There is a legal reason to do it. It's a way to limit damages. So let's say your company is sued for patent infringement. A jury finds infringement. A jury also finds that you couldn't prove that it was invalid, and the jury awards damages. At that point, the plaintiff can say, you didn't just infringe, you willfully infringed. And the judge at that point has discretion to triple the damages. All right. An FTO study and the result of that, which would be called a term of art, an opinion of counsel, can be used as evidence to minimize that damages escalation. And an opinion of counsel is this tool really, it's a defense that says, I reasonably relied on the advice of my patent counsel by reading and knowing what was in this patent opinion of counsel. So therefore, don't increase the damages on me because I had reasonable non-infringement or invalidity arguments at the time that we were developing the product. All right. That is ultimately the end goal or the end product. This is also one reason why some of these documents get a lot of scrutiny and can be it can get expensive because at the end of this process, the attorney and like myself and others are thinking, I'm going to write a document that says this client doesn't infringe. What happens when there's a lawsuit and all those things occur and I'm in a deposition about the opinion? Okay, so an opinion of counsel is a fairly detailed document that really takes into account the situation that you may be in from a willful infringement perspective. And then thirdly, investors want freedom to operate. I haven't met an investor yet that wanted to buy a patent infringement lawsuit. They just don't want to do it. It's one of the many risks of investment or investing in medtech or in any business that involves technology. But investors want freedom to operate. Now, how do we do this? And this is a simple sort of flow chart. The way I going to look at this is, phase one is your patent search. And I would look at the patent search sort of broadly. It doesn't necessarily have to be, you've hired a third party to identify the patents. It could be patents that you know about on your own. We have a number of clients that have alerts on particular inventors and particular patent owners where we see publications that they're coming up and evaluate it. So the idea is however you compile these patents that are more or less relevant to your product, filtering those out till you get to maybe, 5 or 10 or 15 that may be relevant to the patent. Then you're going on to phase two. And you're really asking the question here, does the product infringe the claims of the patents found in phase one? And if you can get through all that and say no, you'd say there's lower risk or freedom to operate based on the search and the scope of search that you had. If you can't find a non-infringement position that's reasonable and cogent and will stand up, then you can go to, well, maybe this patent claim's invalid. This validity analysis. This is a yes or no question. It either is or it's not. And if it's not, you've got low patent risk. If it is valid, you secure a license or proceed in face of the risk. Now, this study is a little bit of this sort of loop. You know, you can go at phase 2, maybe you don't have infringement, but you may be at a stage commercially that you could adjust some aspects of your product to avoid infringement. And this is just sort of typical classic design around analysis where you're designing away from the claim to avoid infringement, you know, more or less. The other thing that I've seen and certain clients do is we have this sort of 18-month gap where we don't know what has been filed in the previous 18 months. All right. So an FTO search based on patents that happened at one point in time will get stale, so to speak, because of this period where the patent office doesn't publish applications until about 18 months after the original filing. So updating this search at certain intervals is a way to make sure you don't get a surprise, you know, down the road. I have a client that will do this more or less quarterly, just to see what's new that has come up, you know, in the past, you know, 4 months or so. And usually, you know, sometimes there's nothing, sometimes there's one or two things, but it's not necessarily an event as much as it is a process that is sort of ongoing. Now, phase 1, we're getting a little bit in the weeds here, but phase 1 or phase 2 of the FTO, it goes something like this. So claim 1 of your patent is a device. It has a brown widget, a gray gizmo, an actuator, and a controller. Product A, you have a brown widget, a gray gizmo, a first actuator, a second actuator, a controller. Product A infringes claim 1. It doesn't matter that there's 2 actuators in the product. The claim only requires 1, and you have every other limitation in your product. So there's no freedom to operate there. Now, let's say we talk with the engineers and they're like, look, I have to have an actuator, at least one. We're going to have 2. The brown widget is essential and the controller is essential, but I can change my gray gizmo to a black gizmo. It's a pretty simple example, but that's a non-infringement argument. I will say just that there is literal infringement, which is the analysis that we just went through, and something called doctrine of equivalence. And doctrine of equivalence essentially says you insubstantial changes that perform the same way and get the same result is still an infringement, even if you don't literally meet the claim. It is a valid doctrine, and that's part of what goes into the opinion of counsel that I mentioned, you know, earlier. But for the sake of just going through the example, a black gizmo is different than a gray gizmo, and there's other limiting factors to that. I'll stop. Mark, you have a question?
Yeah, thanks. By the way, just a quick comment. I was working at a large medical device company way back 30 years ago. And I remember the lawyers grabbing the engineers and sitting around looking at patents to see if we could change whatever we'd seen in somebody else's patent at least 25% so that we could file our own patent.
Right.
So that was just a normal course. But I wanted to go back to continuation for a second. I noticed on your screens you had about every 3 years a continuation. Is there a specific time frame, or is it just regular? Do you have any limitations on when you do these continuations?
That's a great question. You can file a continuation anytime up until what we call the parent application grants or issues as a patent. So in my example, I just picked the dates. You know, 3 years isn't really a time. So patent application, if it granted on January 1, 2018, a continuation would have to be filed by January 1, 2018. And then that pendency allows you to file other continuations down the road. But there is no ultimate limit on how many of these continuations you can file, apart from the practical limit of your patent term, which is 20 years from file.
Okay, so I have a unique situation here with my my Clean Spaces app. We just received our provisional patent. We got a year before we can file our non-provisional patent, which really starts the clock ticking. So you're saying before The non-provisional actually grants. I should be doing my due diligence and looking for every opportunity for anybody else out there or any other items that I could add to the patent and try and file this before I actually get my first patent from the non-provisional.
Right. I'm going to answer the timing question. Is you're correct. So at any time before that non-provisional grants, you can file a continuation. Now, a continuation is taking the same document and refiling it as a new application. All right. So if you're in the, let's say your non-provisional has a method claim, you can file a device claim in your continuation. And if you know of a competitive product, you should try to cover it. What does happen, and this is not uncommon, is you file your provisional, you file your non-provisional, but you're still tinkering and doing development. And what I would say, I think the 25% rule, it's a good rule of thumb, but whenever your new development is sort of getting more far afield from your original filing, the farther it gets is where you would file a new application. And you could file something, perhaps a continuation in part, that adds new stuff.
Okay, great. Thank you.
Greg, you mentioned something that sparked a question when an actor makes an adjustment to their product because they're aware of some potential activity coming down the pike. Is that kind of giving you ammunition to say, hey, you recognize that you were coming awfully close to our patent, so you made it gray? I don't know, is that like a positive thing that I took a proactive step, or is there a flip side to it? It's like, okay, you're showing your hand that you recognize your close and you're trying to
on balance, I think it's a positive thing. What would be worse is kind of knowing that you have a patent out there, knowing that your product infringes it, and then deciding not to do anything. That's sort of classic willful infringement. And it takes some bad actors to really get to a willful infringement determination. But if you're changing your product, that is, there's not a case law that says this, but in my view, it's more, that's the sign of good faith, essentially, to say, okay, I'm going to change my product. It's different. The patent owners are bound by what they write. Okay. That's part of the challenge of being a patent attorney and a patent owner is in this claim, the patent counsel and the patent owner said it was a gray gizmo. He could have just wrote a gizmo and this analysis would be different. It wouldn't matter if it was gray or black, but you wrote gray or you wrote black, or, you wrote that the, cannula has to be inserted into the sheath fully or partially. You're bound by what you write, to some extent. But I think it's in litigation, in the course of discovery, you'll see the development as it progresses, and you'll see it becomes kind of apparent sometimes that, okay, they found these patents and then made a design change, but maybe their design change didn't go far enough.
Stan writes, does new material in a continuation in part get a fresh 20-year expiration date on the new material?
No, it doesn't. That's the downside of a continuation in part. If it's new enough, you just file a separate application and you have a new 20-year term.
Thank you.
Yeah. All right. Patent infringement, patent litigation. Important patent infringement liability, of course, attaches when one makes and uses what is claimed in a valid and enforceable patent. It's not enough to have a claim that covers a product. To Andrew's point, it has to be valid and it has to be enforceable. Remedies, of course, damages, and injunction. An injunction is a powerful thing if a court can order a company to stop selling something. At 10X, we heard an example of patent litigation at the International Trade Commission. All they do is injunctions. They can literally seize products out of port. Really quite powerful. And attorney's fees sometimes, for egregious. Doesn't happen in every case, although probably the majority of cases, attorney's fees are sought, but they're not awarded, every time. We've talked about willful infringement. Patent lawsuits are expensive. This is part of the deterrent, frankly. This data is from 2020, I believe. 2.5 million for each side when more than 25 million is at stake. That's for a single patent. If you look at some of the pharmaceutical litigation that happens, they'll assert 10 patents against a defendant. those are probably $5-10 million cases if they go to trial. 750K when less than 1 million at stake. It's probably a bit higher than that at this point. So this is what investors don't want. They don't want an operating company to be spending, $2.5 million over a 2-year period on patent infringement lawsuit, unless it's existential.
Would you hazard to guess how much AliveCore is spending?
10 million, easy, probably.
I'm surprised it's that low.
Right. I mean, they've got a lot of different cases going on. It's probably more, and they've got, I think, a district court litigation and an ITC. I didn't talk specifically about the International Trade Commission, but one of the reasons International Trade Commission is so attractive is the timing. You can get a judgment within about 12 to 14, maybe 15 months. In district court litigation, that'll be 3 years, maybe longer, and then you still have appeals after that. So, the 2.5 million through trial, maybe over a 3-year period. ITC litigation would be 2.5 million in a 12-month period. So it's expensive. This is one reason why there's such care, I think, taken at looking, especially at freedom to operate.
Andre?
Yeah.
Hey, Greg, just wanted your comment. I belong to a very active group called U.S. Inventors, and we've been working very hard now to have the PTAB modified because of the way that it very strongly affects smaller inventors,
right.
And the unfairness to smaller inventors. And for those of you that are on here, that if you're a small inventor with patents, you might want to get involved with this. But I just wonder, Greg, if you'd comment on the PTAB and the way that it hurts us.
Right. No, I'm glad you brought it up. So what Andre's referring to is the PTAB is the Patent Trial and Appeal Board. It's a tribunal within the United States Patent and Trademark Office. And 10 years ago, the Congress approved new proceedings to invalidate patents through the PTAB. Okay. And the idea was we can make the cost of defense essentially cheaper by making it easier or less costly to invalidate patents. It's still very expensive to file an action, or inter partes review is what they're called at PTAB, is with $400,000 to $500,000. Okay, that's to file it. But if you're a small inventor who's trying to defend themselves, you need to be prepared for defending against that, at least at that level. And so the invalidation rate at the PTAB is I haven't seen statistics recently, but half, I would say, of the patents are invalidated that are filed.
No, it's a shocking 83%.
Exactly.
Oh, right.
Yeah, it's the most damaging thing that's ever occurred, which helps the big companies destroy small companies.
Right.
Exactly.
It's what do they call it? The patent death court.
Exactly.
Yeah. So these are all, the parts of it, parts of dealing with the strategy and the expense of litigation. But I don't know. This is my opinion, not my firm's. But 15 years ago, 10 years ago, the patents were much more favorable for patent owners, regardless of who owned them. Okay, whether it was an individual inventor or a small inventor or not. But part of the issue is this expense in patent litigation. Okay, just a little bit more. Avoiding infringement avoids unexpected costs. If you know where the landmines are, you can try to avoid them. Okay, and I think that's good, just business practice. Designing around a patent can generate new IP. If you're designing around something and your design around comes up with something new, that's an opportunity for developing patents. And then risk mitigation attracts capital. This is true in patents. It's true in a lot of different situations outside of necessarily IP, but it certainly is in this case. Timing for an FTO study. This is a challenging one, frankly. As I said, the FTO study is best when it's focused on what you're selling. And sometimes at the beginning, you don't know exactly what the form of your product will look like. So it's hard, I think, to do a proper FTO study right at the conception phase. This is also one reason why this is a process, not necessarily a single event. But there's some guideposts. So anytime you're about to engage in a significant capital outlay, you're going to file your 510K. You're going to file a PMA. You're going to buy molds for whatever, something that's going to cost 6 figures or more. Then an FDA study is probably warranted, at that time. You may not be in final product form, but before large capital outlays. And then when you make product changes, if you've got a product review process and you're making adjustments, then considering an FDO study at that time. And that's it. Thank you for your time.
Thank you, Greg. Hey, I'm wondering if Jeff is still on the line. No, he's gone. Just anyone who has, perhaps Dr. Lin, are any of the products you're working on now falling in the crosshairs of you deciding one way or another on some of these issues? Or Sue? My manufacturing friends on the call, are any of these issues ones that you have or are presently grappling with?
Very, very interesting topic, and I'm sorry that I have to run to another meeting, but I'll add that it's very important to take into consideration that, color changes and size differences are deemed to be obvious and wouldn't be grounds to distinguish one product from another. So I may have put something together in a very compact gizmo, which then makes it portable. But when I write, when the claim for my patent is written, it would say an assembly of an array of a device comprising a pump, a motor, a sensor, or at least one sensor. So whether they have one sensor, 3, 4 sensors, it's all covered. And so retaining a very skilled patent attorney and working closely with that patent attorney is really critical.
Well, lucky for us, we have a skilled patent attorney in our little family here. Sue, anything to add?
That's great. Thanks. I'm sorry.
I agree with Dr. Lin. Bye, Dr. Lin.
I do. Sorry to have to run, everybody.
Okay.
Thanks. You all have a great weekend.
I'm lucky enough that I do have a really good patent attorney, and I've had to file for amendments for both my first patent and my second patent, and my third patent was accepted and the amendments were accepted. I currently have a PCT pending in Europe. My fear right now is that they're probably building something like this in China and in India, where things don't really matter. And does it matter? It's out there, and maybe it'll save some lives. So maybe I don't really care, and mine will be better anyhow. So I don't know.
As your investor, I care. Mark, you are next week's star. Tell us what we're going to learn.
Okay, well, a little bit about the new software we're developing. And as I was just talking to Greg about some of the things that we're doing with the patents, we got the provisional patent. We're waiting to get it a little further along in the development, but it is a clean room data management package that doesn't exist right now from what we understand. There are a lot of different automated packages that will allow you to automatically do particulate counts in a clean room, for instance. But there's nothing that we know of other than perhaps putting the micro data into sort of a LIMS system. There's nothing for an effective clean room management for cleaning, disinfecting, particle counts, and micro, and be able to automate all the processes that goes along with the QA, having to transpose the data, create charts and graphs. We've automated all of that for you. So I want to be able to present that and show you exactly, if anybody knows people in clean rooms, using paper is just a pain. And
Right,
this is going to alleviate.
Paper is not allowed in clean rooms.
Well, that's not exactly true. There's a certain type of paper like corrugated cardboard that's not allowed in, but there's paper in clean rooms at practically every organization I've worked for, and I work for some very large organizations.
Interesting. Greg, will you be able to join us next week? It looks like he's frozen.
Oops.
Andrea, did you have something you wanted to close with?
Yeah, back to the FTO process, I wanted to sort of warn people that a lot of times people think it's like Greg said, like a checkbox. You do one FTO and you do it on the feature that you have invented, right? But you really need to do the FTO on an entire product. And sometimes you'll have other features that are sort of more known in the art, and all the other products have them, but that doesn't mean that you cannot be sued for those features. Those might not be your invention, but an FTO has to include those as well. So it could be a plurality of searches, a plurality of FTO clearances, and keep that in mind when you're doing them, the cost associated with it. It's not just what you have invented.
I'd love it if you could come next week as well. Let's hear what Mark has to say and see what kind of protections we can afford him.
Yeah, I would appreciate that, Joe, because one of the things we're fearfully concerned with is, how much protection is enough for what we've got, who can take what we've got. I think we've got a pretty robust patent file, but that's why I wanted to ask him about those continuations, because as we learn a little bit more and what we want to add, I want to know about continuations before we get that.
Rich area to explore. So Andrea, if you can, and Greg, I think is still on the call. His video is compromised. Hope to see you all next week. Thanks for joining us, everyone. And thank you, Greg, very much. Bye for now.